Hello, this is Alexander Cross, criminal attorney here in the San Francisco Bay Area. If you'd like to learn more about criminal law, please be sure to subscribe to our channel, Law Offices of Cross and Associates. So here we received an interesting inquiry on our channel. This has to do with hit and run while drunk. So here goes. My son took my vehicle without permission, and he went to a club. Later he ran over a cyclist and left the scene. What will happen? First of all, the first charge that comes to mind is a violation of Vehicle Code Section 10851. This could be filed as a felony for driving somebody else's vehicle without permission. That carries up to 3 years state prison. In a situation like this, if the son has a driver's license, it would probably not be best for the authorities to be aware or to openly tell the police, oh yeah, he took the car without permission, simply because, that's a pretty serious charge right there, and there's no real downside to the father if he let the son drive, provided that the son had a license. If the son did have a license, well, they can file 14604, which is driving some of the vehicle code, which is letting somebody without a license drive your car, and that's a misdemeanor. But provided the kid had a license, probably not best to tell the police that he took the car without permission, unless he may be a suspect. Let's see, he went to a club, later he ran over a cyclist. Well, first of all, if he was drunk, ran over a cyclist, that would be a violation of 23-153 of the Vehicle Code A and B. That is a felony that carries up to 3 years state prison. Plus, they could file an enhancement for great bodily injury that would substantially increase the penalty if the victim suffered great bodily injury. And of course, he left the scene. Well, if you leave the scene of an accident and somebody suffers any kind of injury, even a little scratch, that would be a violation of Vehicle Code Section 20001 as a felony that also carries up to 3 years in state prison. Now, this is the type of case where it really depends on when the police capture the accused, who eventually becomes the defendant. If the police get a hold of him within 5 minutes of the incident, well, they might have all the evidence against him, especially if they have no if they have no alcohol, if he has no alcohol in the vehicle. Because if there's no alcohol in the vehicle and they stop him in the vehicle and he's drunk, well, obviously he would have had to have been driving before, he would have had to have been drinking before driving the vehicle. And hence, if they haven't blown the alcohol test device or they take blood, they may be able to establish that he was at a .08 or more at the time of the driving. However, if the police don't get to the suspect for about 2 or 3 or 4 days later, it would be best, and I usually tell people this anyways, it's best to remain silent. Never talk to the police, because anything you say or do will be used against you in court. If they can't establish that he had any alcohol, you might not be able to be charged with a DUI. And of course, if they can't establish that you took the car without permission, then they can't file the 10851, which carries up to 3 years state prison. So basically, if you keep your mouth shut, the most the DA would probably be able to charge, which is still serious, but not as serious as everything combined, but the most that the DA may be able to charge would be a violation of Vehicle Code Section 20001 as a felony, which would be the felony hit and run. This is the type of case that it would be best to keep your mouth shut, don't talk to the police, don't say anything, because anything that you say or do will in fact be used against you in court. Let the police look for the evidence, and if the DA feels they have enough against you, they can file and your attorney can deal with the case. But this is a situation where if the police capture you immediately, or if you open your mouth, you are only going to hurt yourself. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of having committed a crime and need representation in court, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. See you then.